All right, we're on the record in the 53rd Circuit Court for the County of Sheboygan. We're calling the case of People of the State of Michigan versus Randall Newman. It's filed 20-5914FC. We have Mr. Newman with us from the Michigan Department of Corrections by video. We have his attorney, Mr. Hungerford, present in the courtroom. The prosecuting attorney, Ms. Goodrich, is present in the courtroom. And we are providing public access online to this hearing. And we're scheduled for jury selection and trial to begin a week from tomorrow, July 20th. And this is the prosecutor's motion. It's entitled Motion Regarding Witness Availability, but as I understand, it appears to be a motion to adjourn the trial. Ms. Goodrich, you want to go ahead and argue anything with regard to the motion?
Yes, Your Honor. I planned on Ms. Blunt testifying as to her conflict, but she had to begin seeing clients at 3:30. My motion of amending Ms. Carly Bentley is now available due to changes in her work schedule. So it's Ms. Blunt that will be missing due to a family wedding that she has, and it is her young son, not grandson, that she has the care of and has no one to watch him while in Florida. We have offered to fly her back for the day to testify, and she's unable to do that because she has no one to care for her son during that time. So as soon as we realized that there was no other options, we immediately filed a motion pursuant to MCR 2.503C, absence of a witness, that the motion to adjourn a proceeding due to unavailability of the witness must be made as soon as possible after ascertaining the facts. Trying to set forth the grounds of unavailability of the witness and the diligent efforts that have been made to secure and produce the witness. Ms. Blunt's testimony is essential to this trial. She has been the main therapist for 3 years. She previously testified in this court. As to the child, two of the 4 witnesses listed by the defense are authors of a trauma assessment of the child. She was the counselor who counseled the child after the trauma assessment for a period of years. She can testify about the child's vocabulary, ability to articulate thoughts and events during counseling. She can testify about observations of the child's physical response to the mentioning of Randall Newman. People versus Sickles, 162 Mich. Ave. 344, 1987. One of the reasons that the trial was adjourned was due to witnesses being out of town. In that case, it was found that it did not violate the defendant's speedy trial rights. That defendant had caused some of the delays in this case. In that case, as the defendant has in this case when he switched attorneys, some of the delays in this case have been due to the pandemic. I believe that this is the prosecution's first request in this case for an adjournment or a delay. I'd also point to the court of People versus Jackson, 467 Mich. 272 in 2002. A motion for adjournment or continuance must be based on good cause. I believe that there is good cause here due to the essential nature of the witness's testimony, that the defendant is incarcerated on a 5-year charge in another case in another county, so he would not be prejudiced in any way or had anything changed in any way by having the trial adjourned. Thank you.
Thank you. Mr. Hungerford, does the defense oppose the motion?
Yes, Your Honor. My client is waiting quite some time for a trial on that, and we feel that any type of delay, further delay in this particular matter would be highly prejudicial to my client. My client has his speedy rights trial and things like that that's guaranteed by the U.S. Supreme Court and also the Michigan Supreme Court. So, based on that, Your Honor, I just ask that you deny the people's motion in this matter.
All right, well, Ms. Goodrich, perhaps you could help me out a little bit more, and I'll allow you to make offer of proof as an officer of the court about what Ms. Blunt would have testified to. So I want to ask you some details about this, but without the need for her actual testimony. What is the date of the wedding?
In exchange of emails, Your Honor, her son is under 5. The events would be for a period of time because she would not even be available on the Monday after, because I was going to do a motion to call her out of order, but she still would be out of state during that time. There's a series of events due to this family wedding, bridal showers, couple celebration, wedding, post-wedding, family reunion, et cetera, where she had planned this extended trip in Florida for all those reasons, and that would have been proper.
And do you know, well,
I believe that, Your Honor, it was difficult due to the adjournments due to the pandemic and so forth to kind of plan ahead, when a trial is going or not going, looking around that.
so when did the prosecutor's office subpoena Ms. Vallant?
We've been talking about it. For a few weeks now. I believe that she just received her subpoena on maybe Monday, Your Honor.
Last
As we were
Monday?
talking about possible arrangements, I mean, it was a friendly subpoena process.
Okay, last Monday, July 5th. And today's Monday the 12th.
Yeah, last
Okay.
week.
All right, so you were having discussions before a subpoena, so do you have in your file notes, what day or when did you advise Ms. Vallant of the July 20th trial date?
That I don't have written down.
Well, do you know as you stand here now, when your discussions were with her, I mean, how of recent vintage they are? And I guess what I'm getting at is the trial was scheduled on April 7th and notices went out. And what I'm looking for is how soon after or late after that notice was sent was Ms. Vallant advised of the trial date?
What I can say, Your Honor, is that this trial has been scheduled more than once, and that we usually would try to keep the key witnesses on notice of that, but it was in a change of flux at times because of the pandemic and not knowing what the restrictions would be, so. I'm not sure if there was ever a time where we said, yeah, for sure, we know it's going to be on this July date and all restrictions will be lifted, and please clear your calendar for that.
Well, did you at least tell her when the trial was scheduled for?
It looks like back at the end of possibly the end of April.
Okay, so you have some communications reflecting that you communicated the trial date to Ms. Vallant in April?
Correct, Your Honor. But again, I don't think that we said, hey, hold everything off due to back in April, having no idea when we'd be able to resume trials.
When did she advise you that she had this wedding in Florida?
I think that she probably notified us around that time that she may be out of state.
Back in April?
No, Your Honor, I apologize. The end of April was of 2020 when we were talking about.
Surely you didn't tell her about this then, okay. And just so you know what I'm getting at, MCR 2.503C2 says that an adjournment may be granted on the ground of unavailability of a witness only if the court finds that the evidence is material, which it sounds like it is, and that diligent efforts have been made to produce the witness or evidence. So I think it's incumbent upon me to make a record about, I mean, we had a notice from the court dated April 7th for a July 20th trial date. And I think we have to place on the record, when was this witness notified of that trial date by the prosecutor's office? And when did this witness notify the prosecutor's office that there was a problem with the date? Otherwise, I can't make the due diligence finding.
Your Honor, it does look like we notified her on April 7th that the trial had been moved from May to July, and that she did notify us that she may be out of state in July and for August.
She notified you of that back in April?
Yes.
Well, then why wasn't I told about it in April or May or June? Or even June 30th when we were here talking about sending out summonses to 120 citizens for jury selection?
Your Honor, I believe that I did notify the court the day of the last docket call that I may have unavailability problems with two witnesses. Again, due to the nature of the trial keep getting adjourned and so forth, it was unusual circumstances, I guess, than what normally would occur outside of pandemic.
All right, well, let's go a different approach then. Maybe you can give me more detail. What is the date of the trial? The jury selection is scheduled for July 20th. The trial dates are the 21st, 22nd, 23rd. What family wedding events is Ms. Ballant attending on those dates?
Your Honor, via email, she states it is a family wedding with all festivities happening during that week, bridal showers too, couple celebration, wedding, post-wedding, family reunion celebrations.
So she doesn't specify the particular dates?
No. She's also standing in the wedding, part of the bridal party, and is also coordinating the events.
Do you know the date of the wedding itself?
I do not.
In your motion, you asked for a 45 to 60-day delay. Why that length of time?
I thought that the court's calendar was filled in August, so I was looking at September.
Okay.
But she, August is not July.
And Mr. Hungerford, does the defense not consent to video testimony from Ms. Ballant?
No, we would prefer live testimony, Your Honor.
All right, well, I'm going to deny the motion to adjourn the trial. The court rule requires that I find due diligence to secure the witness. I can't find this on this record. I know trials have been adjourned a lot. This has been the #1 trial on the waiting list for more than a year. Every time we're in court, Mr. Newman is demanding his speedy trial. I've denied his motions to dismiss for violations of speedy trial We've given him this date. We told him you're going to have your trial. This is the date. We sent out a notice. I know we've adjourned things over COVID, but unless and until something gets adjourned, a notice from the court for a date is not a suggestion. It's setting a date. And the prosecutor did advise the witness of the date back in April, apparently was notified back in April that the witness was unavailable, and the prosecutor took no steps until a week and a half before the trial to notify the court and seek relief. On that finding, I cannot find due diligence, so the motion is denied. We will pick the jury a week from tomorrow and try the case.
Thank you.
All right, Mr. Newman, and we're going to transport you on Friday from I signed a writ for you to be transported back to the Sheboygan County Jail on this coming Friday. So you'll be available in the weekend and day before to meet with your attorney. So he's going to coordinate with the jail administrator to make sure that he can have access to you. Okay?
Mm-hmm.
All right, we'll see you next week.
Yep.
Thank you, Jim.
All right, we can call the case of people of the state of Michigan. Oh, actually, let's call Miller while
Okay.
Mr. Hungerford's here. This is on tomorrow's docket.
Yes, Your Honor. I believe it's scheduled for 9 o'clock.
Yes, People versus Sean Miller, file 20-5993. It's scheduled for a docket call and a show cause hearing. And I did speak in chambers with counsel. They indicated that Mr. Miller wishes to call witnesses for the contempt hearing, and so we needed an adjournment to facilitate that. Is that correct?
That's correct, Your Honor.
Any objection to that, Ms. Goodrich?
No objection.
How much time do you need, Mr. Hungerford? I mean, in terms of how long would the hearing be?
The hearing would probably only last, 15 minutes to 30 minutes.
Okay. I could give you 9 a.m. on July 27th.
That's fine.
All right, so we'll continue the docket call and also schedule a contempt hearing for July 27th at 9 a.m. in person. And we'll remove the docket call from tomorrow's docket then.
Okay, and thank you.
Okay, thank you. All right, so now we'll call the case of People of the State of Michigan versus Justin Jermaine Smith. It's file 19-5888 FC. We have Mr. Jermaine Smith present with us in the courtroom, along with his attorney, Mr. Gilbert, and the prosecuting attorney, Ms. Goodrich. Department of Corrections Agent Dudek is appearing on Zoom video, and we are providing public access online. And Ms. Goodrich, I do see NMCAC in the waiting room. I believe that would be a witness for we continued this for an evidentiary hearing on a guideline score. And I was advised by counsel before coming on the record that objection is going to be withdrawn. Is that correct?
It is, Your Honor. I talked with my client. And we wish to withdraw the objection. It should be noted that my addition abilities, maybe my former life as a CPA, did not pay off last week. I added incorrectly, so we don't. The the objection does not affect the scoring. The scoring is correct, and even if we were to gain those points, we don't change in the grid. With that being said, my client is withdrawing his objection.
Okay. Wow, I'm not gonna fault you for that, because I would have thought too, taking 25 points away would change the grid, but it doesn't on this grid?
It doesn't, the OVs are
Gotcha,
16 plus.
16, gotcha, okay. All right, so Ms. Goodrich, do you want me to bring that person in so we can tell them?
Yes. thank
All
you.
right. Good afternoon. I apologize for the delay. And can you hear me?
Yes.
Okay, and I was just informed by the attorneys that the matter that was requiring your testimony no longer requires your testimony.
Okay.
All right, so I'm sorry, I'm not sure that, well, I'll apologize for the delay, but not for telling you not to testify, because you probably don't feel too badly about that. Okay,
No,
but
not a
thank
problem
you,
at all.
and, okay, you have a good day.
All right. Thank you.
All right, so we're here for sentencing then. Let's go ahead and start afresh then. Mr. Jermaine Smith, we're here for sentencing on a charge of criminal sexual conduct in the 4th degree. That is a high court misdemeanor punishable by up to 2 years in the state prison. Have you had a chance to review the pre-sentence report and recommendations with Mr. Gilbert?
Yes, I have, Your Honor.
All right, Mr. Gilbert, do you have any additions or corrections to the factual information contained in that report?
We do not, Your Honor.
Ms. Goodrich?
No, Your Honor.
The advisory guidelines are scored at 0 to 9 months. Mr. Gilbert, do you have any objection to the scoring of the guidelines?
I do not.
Ms. Goodrich?
No, Your Honor.
All right, and Mr. Gilbert, anything you'd like to say on behalf of your client?
Your Honor, my client stands before you remorseful for his actions. He understands that he has done damage to another individual, even though the child is young, that this could emotionally scar the child. And as I said, he stands before you remorseful today. We'd ask the court to place a sentence within the guideline range. I will point out he has no prior criminal history. This is the first offense for him. And would ask the court to take that into consideration and sentence him within that guideline range. Thank you, Your Honor.
All right, thank you. Mr. Jermaine Smith, is there anything that you wish to say, sir?
I made a terrible mistake. I made a mistake.
Well, Mr. Jermaine Smith, you'll have to forgive me here for a minute, but I'm a little confused because at your plea taking, you told me on the record, I went and watched it again so I could know exactly what you said. This is a direct quotation from your plea taking. I pulled her, speaking of your 4-year-old niece, I pulled her onto my lap while I was sitting on the couch watching TV, and I removed her diaper, and I touched her vagina, but I did not penetrate. That was your statement under oath to this court. And then I read in the pre-sentence report that you hate that you had to say you did something when you don't really know if you did or not. You don't remember doing anything, maybe, but you just don't know for sure. You just took the plea since 2 years is better than 25, especially since you don't know if you really did it or not. And then today you give me some tears and say you made a mistake.
Because I'm pretty sure I did do it, Your Honor, even though I don't remember it from my concussions, from my time in school, from all the sports. I get times I just don't remember. And it's entirely possible that this happened in one of them. And if it did,
Well, which is it? Did you plead guilty because you are guilty?
I believe I am. I believe I did it, but I don't know 100% for sure. I believe I did.
Why did you give me such a detailed statement at your plea taking?
I just said what the police report said.
I mean, that sounds like somebody that's remembering some details. You talked about where you were seated, what you were doing, what you were watching. That doesn't sound like somebody who doesn't remember, Mr. Jermaine Smith.
I just said what the police report said because I knew that would be accepted, but I honestly do not remember doing anything. And if I did do something, I do deserve to sit those 2 years, but I don't remember doing anything.
Well, so what am I to do with this? I mean, you're telling me today you don't remember doing anything. You think maybe you did it. I mean, do you want to have your trial?
No,
It's not my practice to take pleas from people who can't tell me that they did it.
I mean, I'll take the deal. I'll say I did it. I believe I did it. I'm sure I did it. She wouldn't just be saying this if I didn't.
So now you're telling me you're sure you did it.
I'm sure I did it. I 100% believe I did it, even though I don't remember it. She wouldn't just be saying this. I know her. She wouldn't have just said this if nothing happened.
You're not going to jail today. You're going to go to prison today.
I know.
All right, Ms. Goodrich, anything from the people?
Yes, Your Honor, the victim's mother, Andrea Martin, wishes to speak.
Okay, Ms. Martin, you go ahead and sit down, Mr. Jermaine Smith. Ms. Martin, you want to come up to the podium? Go ahead and tell me anything that you think. Go ahead, take your time.
Okay. Okay, Your Honor, what a long, almost 3.5-year case of the victim's mother. I hope to engage a storm in you like the same storm that has hovered over my family for years now, with the words I am writing, in hopes of swaying you towards giving Justin Jermaine Smith the max. Every morning when I wake up, I think about my daughter and how the most purest thing she had was taken from her, her natural born innocence. My daughter lost everything that day, we just didn't know it yet. She did what she was supposed to do, which was tell someone. The same family and person who greeted my daughter moments after birth, the same ones hurt her. My daughter went through so much more than most her age due to what Justin did to her. And due to such actions, she suffered from and or still suffers from regressed potty training at the time. Fear of new and previous men being around her, meaning her doctors, friends, my coworkers. Distrust, she went to me for help and lost everything. Nightmares, which are still ongoing, and then decline in academics, the first 3 years of her schooling. And touching her siblings in inappropriate manners, which thankfully due to counseling, this has declined. She also touched her dolls inappropriately for a long time while laying in bed. And finally, she's promiscuous. My 7-year-old daughter's promiscuous because something so innocent was sparked in her. And she also needs constant reassurance that she is enough and she will be okay. The same family and only family my daughter knew, as I don't have family in Michigan, shunned us. Here's that my 3.5-year-old daughter at the time with zero understanding of why. And here she sits at almost 8 years old, still wondering why. Why would Uncle Justin, Nana, and Papa ever do such a thing to me? For years, we have lived a life of weekly counseling with many different counselors trying to help heal my daughter. We have lived a life where, as a parent, this couldn't be kept a secret. We had to tell teachers, coworkers, doctors, and bosses. Do you know how many jobs I lost over the years because of court, rape center interviews, and weekly, sometimes twice a week counseling? I've had to beg and plead with my bosses. I've lost 3 jobs over the years due to this case, begging and pleading because my daughter was molested by her uncle, not even in my care. As a parent, do you know how shameful that was? Taking points and write-ups with tears in my own eyes because I needed to take care of my daughter. I was doing this all alone with no support system. Throughout the years, I've been asked to write on forms for restitution or for mileage coverage, even when needed. Even when needed at times, I never lifted a pen for those pages because no dollar amount will give my daughter back her innocence. I pray with all my being as a person, as a mother, that Justin is sentenced with the maximum that is allowed. While he may only get a small fine or a year or so in jail, my daughter will live with this for the rest of her life. This will resurface with her first boyfriend. It will haunt her in moments of happiness. This won't be a closed book. It will be a closed chapter. We will heal no matter what, like we have through these years. On the hard days, I have said to my daughter, we are strong because we are fighters, and that's just what we are. I pray that you find it in your heart to sentence Justin Jermaine Smith with the max so we can close this chapter. We are ready to just be strong and no longer fighters. And that's all I have.
Thank you, ma'am. Ms. Goodrich, any recommendations from the people?
Your Honor, in addition to Ms. Martin's statements, I just asked the court to take into consideration the defendant's lack of accountability for his actions, the lack of remorse, and that the focus in his PSI interview was more on himself than how this has impacted his niece. And I'd also ask the court to continue the no contact with the victim. Thank you.
All right, Mr. Jermaine Smith, you want to rise for the sentence of the court? Guess I just want to confirm for this record then, Ms. Goodrich, do you believe there's a sufficient factual basis to support this plea?
I do, and for the reason also as stated in the PSI.
Mr. Gilbert, do you believe there's a sufficient factual basis to support the plea?
I do, Your Honor.
And Mr. Jermaine Smith, are you being sentenced today for criminal sexual conduct in the 4th degree because you're guilty of that crime?
Yes. I believe I am, yes.
All right. Well, Mr. Jermaine Smith, that crime carries with it a maximum penalty of 2 years in prison. This court doesn't choose the charges. It doesn't choose the plea bargain. It's no surprise to defense counsel and the prosecutor that I think it's a terrible outcome. There's nothing I can do today that's going to be sufficient to respond to what you've done. All I can do is what I'm allowed to in the law. And what I'm allowed to in the law is there's a maximum of 2 years. And we have indeterminate sentencing in Michigan, so I have to determine what the minimum sentence is. The advisory guidelines range is 0 to 9 months. That guidelines range does not take into account the gravity of this situation. You removed another human being's diaper to sexually assault that human being. You did engage in sexual penetration with that child, which would require a mandatory minimum in prison of 25 years. That's what you deserve today. The law says that's what the response is to somebody who sexually penetrates. If you're 17 years of age and you sexually penetrate somebody under 13, a 12-year-old, the law says 25 years in prison minimum. That's what the law requires. You sexually penetrated a 4-year-old who was your niece. And I can give you only a fraction of that. And it's a crying shame today. But I can't follow those guidelines. They don't even come close to touching the severity of what you've done. The law says that in determining the minimum, I can only set it at 2/3 of the maximum. Otherwise, we don't have indeterminate sentencing. The parole board has no area of jurisdiction. So the very most that I can sentence you to by law from the plea-based outcome that's been handed to me is 16 months in the state prison. I can only give that if I find that your case is among the worst CSC 4th cases. I find that it is. CSC 4th is sexual contact without consent. This was, you engaged in sexual contact and penetration with a 4-year-old who was your niece. And you're still hedging on whether to take responsibility for it. You tell me under oath what you did in detail. Then when you're in front of the pre-sentence investigator, you try to hedge your bets and say you're not sure you did it. Then you come here today and give me crocodile tears and for sympathy or something, I don't know. And then you're telling me, yeah, you're sure you did it. I'm sure you did it. But you have taken no responsibility for it, no real responsibility for it. You have no real remorse for it. You've never shown any in this case, not even today. Nobody's fooled by those tears, Mr. Jermaine Smith. So I do believe you are among the very worst of criminal sexual conduct fourth-degree offenders that I have ever encountered in my 20 years of practice. So I will do the maximum that the law allows me to do. So I will commit you to the Michigan Department of Corrections for a term of not less than 16 months, nor more than 24 months. You'll have credit for, let's see, it's 52 days plus from last Tuesday to now is what, another 7 days, Agent Duday?
That's correct, Your Honor.
All right, so you have credit for 59 days previously served. There's mandatory state costs of $68, crime victims assessment of $130, DNA fee of $60, court costs of $350. And just so that I can do every last drop of what I can do, I am going to assess a fine. The maximum fine is $500. I'm going to assess that fine. This is a departure from the guidelines, and I have explained both the basis for the departure and the extent thereof. So that's the sentence of the court. And Mr. Jermaine Smith, you are able, if you wish, to file an application for leave to appeal to the Michigan Court of Appeals to challenge your conviction or my sentence. If you can't afford an attorney, we would appoint one for you at public expense, but you would have to make that request within 42 days of today's date. Or if you knew that's what you wanted to do, we'd give you a chance to fill it out even here in the courtroom. One copy of those appeal rights is for you to fill out or for you to initial so that we know that you have it. And the other one is for you to fill out if you wish to appeal. Do you have any questions about that, sir? All right.
Sorry, I thought it said sign.
All right.
And our last matter on the docket was Pulowski. Are we ready to do that, Counsel?
We are, Judge. I understand that the arraignment room is being used.
We can bring him out in person if you
Is
want.
that okay?
Yeah, that's fine.
I-
Is he going to bring a tie with him for you? We'll excuse it. We'll
Thank you,
excuse it. All
Judge.
right. Yes, please. All right, so we'll come back on the record and do Pulowski, front of the court matter.